following program on Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the recent judgments on local government elections in Sri Lanka. What do these deliberations spell out for the future of democracy in the country? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something that's very relevant with the upcoming elections as well. We're going to be talking very in-depth about the recent judicial, the judgments that have been made by the Supreme Court relating to the local government elections and also the stay orders and whatnot. First of all, it's of course a very convoluted topic considering just how the communication has been going on between the courts in itself, but it's very important that us as voters get an understanding on what exactly the legal background and environment is when it comes to local government elections in our country. So to speak about this, we have someone that's very well suited for this program, and that is Mr. Shantha, Jayawardena, attorney at law. So thank you very much for coming down to the studio today a little bit last notice to actually give us a little bit of an insight onto how to navigate this legal chaos that we have seen with the courts recently. A little bit of an introduction into Mr. Shantha Jayawardena. He is specializing in fundamental rights applications and writs as well. So safe to say, when it comes to 90% of this program, we're going to be talking about those specific writs. A little bit of a background on how we're going to navigate this discussion. We have to talk about the current context when it comes to the elections. But before that, let's get to the fundamentals of how local government elections are actually navigated in our legal sphere. Next, we'll be talking about the current context and the writs. And finally, we'll be talking about what we can expect moving forward for the future of elections in Sri Lanka. Alright, well, without any further ado, let's get right into the nitty-gritties of this topic. So thank you once again. We have a lot to cover, but before we cover any of the specifics related to the writs, it's important that our audience actually gets an understanding on what exactly the legal mechanisms are when it comes to navigating local government elections specifically. Can you give us a brief overview of the current legal framework that governs local government elections in our country, specifically when it comes to the recent challenges as well?
Yeah, thank you very much, Anuradhi, for inviting me for the program. The law that is relevant or applicable is primarily the Local Authorities Elections Ordinance, which is a law enacted before the independence in 1946, and that is the primary legislation which governs the local authorities elections. Then, of course, in the background we have the Constitution, which is the basic law, which has certain principles relating to elections which are applicable to local authorities elections as well. So Article 3 of the Constitution says franchise is part of sovereignty. Then under Chapter 14A of the Constitution, the Elections Commission is established, and certain powers are given to the Elections Commission to conduct free and fair elections. So now in that constitutional setting, only the Local Authorities Elections Ordinance governs the local authorities elections. Of course, the Parliamentary Elections Act of 1981 also has some relevance because that law deals with the recognition of political parties. So the Constitution recognizes certain principles, then Parliamentary Elections Act provides for recognition of political parties. Those principles are relevant, and the provisions of the Parliamentary elections are relevant when it comes to recognition of political parties who contest local authorities elections. Then primarily the Local Authorities Elections Ordinance, which is enacted in 1946, and I counted today there have been 24 amendments to that since 1946. So that's quite a lot. So that's the legal background in which the election is conducted.
So you mentioned that there were amendments that were made since its inception, the inception of this act. Recently also we see a lot of communication relating to how local government elections must be carried out, and also what actually qualifies certain parties to actually take part in the election in itself. is the Act lagging a little bit behind when it comes to modern challenges, or do we see that it is stable enough to carry through?
I don't think it's lagging behind. The issues that come up is maybe partly because if you look at the history of the statute, in 1946 when it was first enacted, the electoral system that was provided for in the ordinance was the first past the post system. That's a simple majority system where the candidate who gets most number of votes for a particular vote gets elected. That was the electoral system which was provided for in the ordinance. Then in 1980s, after the 1978 constitution, which introduced the proportional representative system for parliamentary elections and also for provincial councils, the local authorities elections ordinance was also amended to provide for the proportional representative system, which is completely different to the original representative system. And then again in 2017, to make it more complicated, of course the intention was to ensure more participation on the part of women, and then to give better representation to the people. So it was amended again to introduce a hybrid system where certain number of candidates are elected for particular votes directly based on the first past the post system. Then certain number of members are elected based on the proportional representative system. So the law was in these 24 amendments, on several occasions the law has been tinkered with to provide or to cater for different representative systems. So that is why there is I would say the statute lacks the flow that you see in an ordinary statute. When you look at a statute, you see a flow, but this statute lacks that flow because there have been so many amendments introducing different concepts into the statute. So that is why it lacks statute. Perhaps it is difficult for public officers and laymen to understand some of the concepts and the provisions. Of course, eventually in a court of law, the lawyers and judges who are trained to kind of interpret and understand statutory provisions will get the correct meaning. But I believe for public officers like returning officers or elections officers, perhaps it's a bit difficult. So those are complications brought by the different amendments introducing different concepts. But it's not lagging behind, but we have made it after 2017. We have tried to, or the legislature has tried to make it a more a democratic process. So that's where the statute stands. So it's not lagging behind. It's up to date, I think, but it's complicated given the history of it.
Exactly. So the convolution is where the main issue lies. I think you pointed out a very important aspect, which is on returning officers as well, and also specifically individuals that are part of the entire process. So I want to move on to the specifics you mentioned relating to officers and individuals that are participating in the local government election process as well, and also about the issues relating to the convolution of the act that we have in place. But before that, let's get to the current context, specifically relating to the lifting of stay orders that we have seen recently. Can you please give us some insight into the lifting of stay orders and what exactly that entails for our upcoming elections?
As I said, the law is there. The applicable law is in the local authorities elections ordinance. So that provides for acceptance of nominations to contest elections. Parties and independent groups have to submit nominations. So one section provides for the manner in which the nominations have to be tendered. That is section 28. So section 28 of the local authorities elections ordinance provides the procedure in which the requirements with which the candidates who submit nominations have to comply with. So submission of nominations are in accordance with section 28. Then there is section 31 which gives the power to the returning officers to reject nomination papers if they are not in compliance with the requirements in section 28. So that is what we see here. Also, certain nomination papers have been rejected by the returning officers for various electoral areas on the premise that those nomination papers are not in compliance with certain provisions or certain requirements laid down in section 28. So they have acted under section 31, saying that the candidates have not complied with section 28. Then the candidates have gone to court challenging those decisions. So what happened was initially, what we see as a large number of cases, I think there are two reasons. One is that now under the new system after 2017 amendment, there are two lists, nomination papers tendered, two lists. One is for the representation based on the vote, that is the old system of first past the post system. Then there is another list tendered for the proportional representation. So the number of lists or nomination papers submitted is now double the number that was required before 2017. So there is an increase in the number of nomination papers tendered. So there is a greater chance of greater number of nomination papers are getting rejected. So that is what we see as a large number of cases. So since, if assuming before 2017 there were only 3,000 nomination papers, if there are the number of parties and the independent groups remains the same. If there were only 3,000, now for the same number of parties and independent groups, this time there would be 6,000 nomination papers. So the number of rejections are increased. So that's why we see a lot of cases coming up, and also with the introduction of new concepts like the women's quota, the youth quota, of course, there for some time. So with those new concepts, new requirements coming in, there have been a lot of rejections, and also initially, because the second reason for the number of cases to increase, I think, is because in the first instance the Court of Appeal issued an interim order. So several other candidates whose nomination papers had been rejected and who had not initially come to court at the first instance itself, after seeing that the court has intervened and granted relief by order staying the election for until the court looks into this matter, the others also who had similar grievances have come before court. So the number of cases went up. So that is why we see it as a major issue. But even in previous elections, nomination papers have been rejected by returning officers for various reasons, and those have come before court. So that is what we see. So the stay order lifting was, I believe, in some cases the Court of Appeal had issued interim orders, but after hearing both parties, the court has lifted those interim orders. But in some cases, court has heard and concluded the matters and given final relief, and in some cases the court has heard and concluded the case and dismissed cases. So there are two categories of cases. One, they've already been heard and decided in favor of the petitioners granting relief. That is in effect saying that the returning officers were wrong in rejecting nomination papers in those instances. Then the other cases where the Court of Appeal has said nomination of papers was rejection of nomination papers by the returning officers were correct. So there are two categories of cases in which relief granted and relief rejected. So we can go into the
Exactly. I wanted to go into the two specifics as well, but I think we should start with the well, I would say rejected applications, nominations. The procedural aspect is what a lot of the writs that we saw come about focused on when it comes to why there was a rejection in the first place. Can you explain to us how exactly that has been justified, specifically like when it comes to future nominations as well? What kind of precedent does it set, the fact that there were so many nominations that had procedural defects or issues when it comes to moving forward?
But I went through most of these cases that were concluded, the judgments which are there available on the websites of the two courts, and what I see is that in almost all these cases, the issues has been that nomination papers have been rejected by returning officers for non-compliance with Section 28. Section 28, as I said, there are various requirements. For instance, Section 28 C, 28.2c requires or provides for the manner in which the nomination paper has to be submitted. Say if it is a political party, it has to be the secretary or an authorized agent of the secretary. Then if it is an independent group, then the leader of the independent group or an authorized person of the leader, the group leader. Then section 28.4 requires an oath or affirmation in accordance with section 7th schedule of the constitution, where not only the elected officers, even senior public officers are required to take an oath that they will not support separatism. So that's the oath in the 7th amendment to the 7th schedule to the constitution. So there's a requirement in section 28.4 to provide that oath or affirmation. Then in section 28.4a, there is a requirement to submit a certified copy of the birth certificate of youth candidates. As I said, there is a quota for youth candidates. 25% of both lists, there has to be a minimum of 25% youth candidates. So for those youth candidates, the law requires, section 28.4a requires that certified copies of their birth certificates have to be tendered, or instead an affidavit saying that he was born on such and such a date and he is of that age or below, that is saying below 35, between 18 and 35. So it is on the basis that these one or more of these requirements are not complied with or not met with by the nomination by the parties or independent groups tendering nominations, that returning officers have rejected those nominations. So then they challenge before the court. So in one set of cases, for instance, in the Court of Appeal, one set of cases, the candidates or the independent groups or the political parties had submitted originals of their birth certificates, the original itself. But the section says, the section 28.4a says a certified copy. So the returning officers thought, no, he has given the original, not a certified copy. Then they have rejected nominations. That on those cases, in all those cases, the court said that is wrong. If the original itself is tendered, then it is sufficient, because certified copy is an alternative to the original. So on all those cases were held in favor of the petitioners, and the court said rejection of nominations is bad. Then there was another set of cases in the Court of Appeal where certain parties and candidates, independent groups, had tendered photocopies of birth certificates certified by the Justices of Peace. We refer to them as JPs, so they are certified by JPs. So the returning officers have rejected them on the basis that it is the Registrar of Births who has to certify a document as a certified copy of a birth certificate. So because the law says it is the person who keeps the original record who can certify a document as a certified copy of the original. So it was on that basis that the returning officers had rejected the nomination papers, because they had not tendered copies certified by the Registrar of Births. Instead, they have tendered copies certified by the JPs. So returning officer said that is not sufficient. Then they came before court. In those cases, the Court of Appeal said certification by JPs is sufficient. You don't have to get a certified copy from the Registrar of Births. So on that basis, the Court of Appeal granted relief in those cases as well. Then there were another set of cases where the candidates and parties had tendered just photocopies without a certification from a JP or an attorney at law. So those cases, the court said that is not sufficient, a mere photocopy is not sufficient. Those cases were rejected. So there were three categories of cases when it came to birth certificates. So those are the cases primarily dealt with by the Court of Appeal. Then there was another, with regard to birth certificates, there was another set of cases where this oath or affirmation in terms of the 7th schedule to the Constitution was not attested by there is an oath to affirmation saying that you will not espouse for another country, division of the country or advance separatism. So in that oath to affirmation, there have been no affirmation by a attestation by a JP or a commissioner for oaths. You know, when there's an affidavit, you have to have it attested by a JP or by a justice of the peace or a commissioner for oaths. So in these cases, their affirmation or the oath had not been attested by a JP or a commissioner for oaths. So on that basis, they had been rejected. So that was also when in those cases the Court of Appeal said there is no requirement in terms of the provisions in the 7th schedule to the Constitution for the oath or the affirmation to be attested by a third party, that is by a commissioner for oaths or a justice of the peace. So on that basis, the Court of Appeal said the rejection of nomination of papers were wrong. Those rejections are wrong. So
I do have to unfortunately cut you off there because we have to go in for a short commercial break, but I want to get into the continued specifics of what exactly the reasoning was and how relief was granted for specific areas. Even though we got through just birth certificates and auto affirmations, I'm sure there were quite a few others as well relating to how the returning officers actually handled the nominations. Before we get into any of such specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with Mr. Shantha Jayawardena, attorney at law. We just got a lot of insight into the fundamentals as well as the current context relating to the local government elections and also the judgments delivered by the Court of Appeal specifically. If you could, sir, I had to unfortunately cut you off in the middle there in the previous segment before we went in for a break. We just got done finishing discussions about birth certificate issues as well as improperly certified documents, other documents, and also affidavit problems. Can you please continue where we picked up specifically relating to the grounds for rejection and how the Court of Appeal and also the Supreme Court actually went about?
Yeah, the Court of Appeal cases covered those areas that I mentioned earlier. However, what we must notice is that it was not on the basis of a procedural impropriety that the Court of Appeal intervened. The Court of Appeal, the contention of the petitioners were that they have substantially satisfied the requirements of Section 28 with regard to birth certificates or affidavits or 7th schedule affirmation. So their position was that they were in compliance with the statute, the requirements in Section 28, but still the returning officers rejected them. So those decisions were substantively wrong. So it was on that basis that the petitioners went to court, and the Court of Appeal in some cases, as I said, held with the petitioners, especially when they had submitted originals and then documents, birth certificates certified by JPs. The court said the returning officers were wrong, but when they had submitted just photocopies, mere photocopies, the court rejected. And what is important here, Anuradha, is that on the same allegations were brought before the Supreme Court in two different ways. One is by a few FR applications. Certain petitioners went to the Supreme Court. Then certain petitioners went to the Supreme Court by writ applications. So there, with regard to the writ applications, the Supreme Court said Supreme Court has no jurisdiction in view of Article 104H of the Constitution. So that is one area I think we'll have to discuss, because there's a lot of confusion among the members of the public as to why one court rejected it while the other court allowed it. So
exactly.
When the Court of Appeal allowed writs, the Supreme Court rejected writs. So the reason for the Supreme Court to refuse or reject those dismiss those writ applications was because the court found that they have no jurisdiction, the Supreme Court has no jurisdiction with regard to the decisions of the returning officers, because Article 104H of the Constitution says the Supreme Court will exercise jurisdiction in respect of the decisions flowing from the exercise of power by the election commission itself. So we know that generally the power with the writ jurisdiction is with the Court of Appeal under Article 140 of the Constitution. In certain exceptional situations, the law or the Constitution can confer jurisdiction on the Supreme Court. So this is where this is one of those instances where the Constitution itself transfers or gives jurisdiction to the Supreme Court, but the jurisdiction is limited. If the decision or the action is by the election commission itself, then the jurisdiction is with the Supreme Court. Here the issue was with regard to decisions made by the returning officers. So the Supreme Court said, look, these are decisions by the returning officers, not by the elections commission. Therefore, we have no jurisdiction. If it was a decision by the elections commission itself, then we will exercise our writ jurisdiction. It was on that basis that those writ applications failed. The Supreme Court did not go into the merits of the cases to decide whether the returning officers are right or wrong. At a threshold issue, on a threshold level, the Supreme Court said we have no jurisdiction. So that is why those writ applications were dismissed. However, there were several fundamental rights applications also filed in the Supreme Court under Article 126. We know Supreme Court has the fundamental rights jurisdiction over executive or administrative action. So some petitioners went to the Supreme Court as by way of fundamental rights applications. So those cases, the Supreme Court went into the matter because obviously the court has jurisdiction. There was no issue of jurisdiction there. The court looked into those matters and refused leave to proceed with all these applications. We know in fundamental rights applications or also in writ applications, there are two stages. In the first stage, the court will look at the cases to see whether there is a prima facie case, and if there is a prima facie case, court will proceed to the next stage, the main hearing. So here the Supreme Court in those fundamental rights cases said the court there is no prima facie case presented by the petitioners, but there is an issue because the Court of Appeal and the Supreme Court findings are different. Now with regard to the birth certificates, the Court of Appeal, as I said copies certified by JPs are sufficient. But the Supreme Court said no. The section says certified copies. So the certified copies, they have to be certified by the Registrar of Births. So unless you produce a certified copy, a certified birth certificate certified by the registrar, you are not met with the requirements of section 28(4)(a). So on that basis, the Supreme Court rejected those cases. So while the Court of Appeal was liberal, if I may use that word, were willing to allow the certified copies certified by JPs, the Supreme Court was not. Supreme Court took a different approach and said no, you have to comply with the law. The law is very clear, it says certified copies and it has to be certified by Registrar of Births. So there is a difference in the findings or the thinking of the two courts. But of course I do not know whether the elections officers or the returning officers appealed against the judgment of the Court of Appeal to the Supreme Court. That I do not know. We are unable to verify from the websites. But the findings are different. Then also with regard to the 7th schedule affirmation or to affirmation, also the stance of the Supreme Court is different. The Supreme Court says that the affirmation or the oath in terms of 7th schedule to the Constitution has to be attested by a JP or a Commissioner for Oaths. The Court of Appeal said that requirement is not necessary because the Constitution doesn't say that. The format in the Constitution doesn't refer to a attestation by a JP or a Commissioner for Oaths. So there also the Supreme Court took a different stand. Supreme Court said the law requires the affirmation to be attested by a JP or a Commissioner for Oaths, otherwise it has no force. So on those two grounds, the two courts differed. Of course, we know the Supreme Court is the highest court, but unfortunately these cases were heard simultaneously. So there's no, if the Supreme Court had decided cases before the Court of Appeal, then of course the situation would have been different. The Court of Appeal
would have complied.
parties will urge, or the respondents would have urged the Court of Appeal to follow the Supreme Court judgments, the findings, the judgment. So here the causes were heard simultaneously. The Court of Appeal pronounced the judgment before the Supreme Court pronounced the judgment. So that is what happened. So there was a confusion because these two different stands, some people are confused, but that happens in law. It's not a static thing. Judges look at it differently, lawyers look at it differently. So with the time, the courts look at them differently. So there is a difference. I do not know how it will affect the next round of nominations or elections with regard of local governments, or even perhaps the other elections if similar provisions are there. So we'll have to wait and see how the authorities act, or whether the elections officers, the returning officers, will appeal against the judgment of the Court of Appeal. We'll have to wait and see.
Exactly. We do have to wait for a response basically for the judgments made. But there's also, before we go in for a break, sir, a very curious question relating to, there's a bit of a clash, as you mentioned, relating to the judgments, simultaneous judgments being deliberated. What does that spell out for the basically judiciary and its flow when it comes to, the Court of Appeal has starkly different views to the Supreme Court, despite the Supreme Court being the most superior court in the country. What does that spell out for? As you mentioned, we have to wait and see about what it will mean for future elections. But as of the moment, what does that even translate to for political parties that are applying, and also for the public that is awaiting some sort of clarification on this issue? What's the right way?
No, that happens. That is not something unusual, because the Court of Appeal heard the cases simultaneously. That's at a different forum. Then Supreme Court is of course the higher forum, heard simultaneously, separate from the Court of Appeal. So they come to do different findings. So if the election or the returning officers are unhappy with the judgment of the Court of Appeal, they can appeal to the Supreme Court and see whether the Supreme Court reverses those judgments or the orders. So otherwise we'll have two conflicting judgments, but the public officers will have to fall in line with the Supreme Court finding, because that's the highest court, and we all have to, the other courts and the officers will have to comply with the findings of the Supreme Court.
So that does mean that when it comes to the conversation with the returning officers as well, there is an entirely different conversation there on to how exactly the law looks upon certain, decisions made by them when it comes to accepting or rejecting nominations. I want to get into that specifics as well, and also what we can see moving forward, maybe what suggestions will be there and what streamlined processes can be expected when it comes to following elections as well. But before we get into such specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment. Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Shantha Jayawardena, attorney at law. So thank you very much for the previous two segments. Unfortunately, it's a very vast topic, so we are only able to very quickly cover the basis of the current context and not able to get into ruminating the specifics of what we can expect for the future. Before we get into anything that is more future focused towards the end of the program, I want to ask you, sir, relating to the returning officers. They have become somewhat of the central aspect of this entire scenario, which is the rejection and also the acceptance of nominations. Can you tell us exactly, does this current legal situation bring the need, or actually clarify the fact that we need clearer legal guidelines that they can follow in order to accept or reject tenders?
Now, we saw different situations with regard to rejecting nominations where the parties had tendered originals. I would say that is a bit disappointing, but apart from that, the other issues were a bit contentious. You can't say the returning officers acted kind of irresponsibly. They have strictly tried to follow the statute as they understood it. So of course But if you look at the thing of the Court of Appeal was that the elections, which we look at as a process where people participate in governance. So that is where the Court of Appeals thought it is better to relax or not to be over technical about the requirements. So it is on that basis that the Court of Appeal has found that the returning officers were wrong, not because there was any malice or any other allegation. So how I see is that there's nothing alarmingly kind of negative about this. The courts are there for the people to come and complain or have their grievances adjudicated. So the decisions made by the returning officers have been brought before the court, and the Court of Appeal has discharged its function or its role in judicial review to review the decisions of public authorities. So I don't see anything pessimistic in this. So it's, in a sense, it's good for people have come forward and challenged the decision of the returning officers to exercise their right to participate in governance. So returning officers can't say they've acted maliciously, but they have made errors of judgment.
Exactly. So it's just, well, apart from some of the more simple aspects, a lot of them have a bit of convolution relating to just how strictly to follow certain guidelines that were already in effect. And of course, that's the important thing to note, which is it wasn't done out of malice so far as courts have deemed. Specifically, it's a procedural issue and also a discretion issue. I want to ask you, sir, relating to representation and inclusion issues as well. Recent petitions actually did revolve around the inadequate representation of women and also youth candidates, as you mentioned, 25% for youth, and I believe about 50% for women. Of course, we need to talk about how significant such representation is, but also what challenges have arisen when it comes to enforcing such quotas.
In one of the fundamental rights cases that has been adjudicated by the Supreme Court, the issue with regard to the female quota was considered because their nomination paper had been rejected, and the petitioners contended that their nomination paper was not liable to be rejected in toto, but it was but the returning officer could have done was only to remove the candidate who had not submitted a certified copy of the birth certificate. But of course, the Supreme Court said, no, if by the removal of one particular candidate from the nomination paper, removal of one candidate by the nomination paper, if that renders the nomination paper to fall short of the percentage of number of female candidates or the youth candidates, then the nomination paper has to be rejected in toto and upheld the decision of the returning officers. The Supreme Court thought if the Supreme Court interpreted it otherwise, as claimed by the petitioners, then the political parties can use in particular the youth quota, kind of to submit names without birth certificates to merely satisfy the requirement, but without in effect fielding the youth candidates, because their names get removed from the nomination list, but still the nomination paper is valid. So the court thought to have the quotas enforced, the court had to reject that argument where nomination is by removal of candidate. If it comes below the quota, then the nomination paper has to be rejected.
Exactly. And I wanted to ask you, relating to the rejections as well, what are the practical implications of the decisions that were taken by the Court of Appeal and the Supreme Court on the upcoming local government election?
So the election is fixed for 6th May, if I remember right.
Yes.
So I think by the first week of April, all these cases were concluded. By the Supreme Court order had it was on the Supreme Court orders for on 4th, and the Court of Appeal orders, some were on 2nd and some were on 4th. Right. So yes, some 1/4. So that left about more than 1 month for the elections officers to deal with the election. I believe so. The interim stay orders granted or the interim reliefs granted by the court initially will not have a major impact on the process. So they should be able to manage within the rest of the time that was available to them, that is 1 month and 2 days. Had they proceed with the, for instance, the printing of ballot papers or the voters lists. Candidates lists, then if they had proceeded with those with regard to the other areas, other electoral areas or councils or sabhas, then I don't think would have caused much of a practical difficulty.
And so while we understand that it's not properly clear to us at the moment on what these judgments actually entail for future elections, in your opinion, do you believe that these recent deliberations that were held will help to give more clarity to future nomination processes for future elections?
Yes, I think now with issue with regard to the birth certificates has been there from about 2002. In 2002 also there have been few cases. So this has been there, but so it's, I believe with regard to birth certificates, of course, it would be a certified copy, certified by a registrar of births is not as far as I see, because to ensure more participation of people in an election process, a copy certified by an attorney at law or a JP would be sufficient for with regard to the birth certificates. But perhaps the political parties will have to lobby the government to relax the requirements with regard to the certified copies of the birth certificates and the oath and affirmation of the 7th schedule of the Constitution. So perhaps it's time to look at amending the laws. Now we have amended it for 24 times, so this will be a minor amendment. So perhaps the law will have to be, the statute will have to be amended to relax the requirement and make sure to ensure more participation of people.
Exactly, and unfortunately, while our time is coming close to an end, I wanted to ask you specifically that question as well, sir, relating to the amendments and changes that we can expect to be made. In your opinion, what is the most urgent area that needs to be a focus on?
I believe with regard to the issue of birth certificates, the rule will have to be relaxed, because there is a limited time to tender nominations. Once the election is declared, there is a time schedule. So, and also sometimes the candidates who are the candidates that would be fielded by a party would be decided at the last minute. So if a copy of the birth certificate certified by a lawyer or attorney at law or a JP is accepted, and if there is a issue, of course, that will be raised if it is a forged, but even an original can be forged. So I think to be practical and to ensure more participation, birth certificate requirement will have to be relaxed.
Exactly. Unfortunately, that's all we can cover today, as our time has come to a close. Thank you very much, sir, for trying to explain the entire gist of the current legal situation that we see in relation to local government elections. I believe that was quite a bit of explanation. Thank you very much.
Thank you very much, Anwar, for inviting me.
All right, well, we'll leave you tonight with the words of former Minister of Mainland Affairs Council of the Republic of China, Tsai Ing-wen. Democracy is not just an election, it is our daily life. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Derana English. Thank you very much for watching. Have a good night.